Huh? Item 16. I was under the impression that people were trying to have matters listed. Yes. Case diary is here. Learned APP has submitted that the case diary has been received. The Learned Counsel for the petitioner has prayed for an adjournment in the matter. Let this matter be listed again. Not possible. It has to go to the end of January. Cannot be. Don't have this space, sir. Yes, do it today. Case diary is here. Huh? Even then it is beyond 21st. 21st I can give you. 21st is the best date. Huh? Why? No, tell us. You have to give us the reason you are not taking up the matter when the case diary is here. You don't want to take up the matter. We'll see whether the updated is not, whether with those materials on record we can give some relief or not. Huh? 21st. 21st. This second on 21st. 2101, huh? Yes. At 48 at 2. Be here, we'll try. We'll try. 30? 34. For what? The CJ has directed it to be listed. Sir, do you see in the list? The CJ has asked it to be listed. I cannot, once it is come on by order, huh? We'll see. We'll do what is required to be done. We are not harming the case. Okay? Yes. 46, huh? Huh? We'll allow it to appear. Give us slip, they'll call for it. For today is আজি মই withdrawal কাৰণে allow কৰিব পাৰিম নে? নে senior bench আছে? Withdrawal to পাৰিম. হয়নে? Yes. 24, yes. PCR office note. Huh? Everything is here, huh? Huh? Everything is here. After vacation will be the first week of February. 21, we have just filled the last slot. 27th? Huh? 27th? 28, yes, 28. At the request of the Learned Counsel for the petitioner, list this matter again on the 28th of January. 28, huh? 12, yes. At the request of the Learned Counsel for the petitioner, passed over for the day. You will have to take it. It's a BA. Again, it goes to 27 or 28. 27th of January. 22. Yes. It may be called for. Ah, yes. এইটো গুচাওক এইখিনি বাগৰিব। Yes, sir. Huh. Hmm. 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 But that is yeah. Hmm. When was he arrested? 5/12. He's using several accounts apparently. Which one? Hmm. Hmm. Yes. Mahajan, let us not go into such long issues as of today. We'll just try to find out anything. Oh. Hmm? That is okay, but how do we stop him from doing this? Fake IDs will not be able to trace out all the fake IDs. Using own IDs was a different thing. We can impose a condition, but when he's using fake IDs, how does anyone trace it out that it is his ID? It will be very difficult. And, within a period of 2 weeks, if he's allowed, message would not be very understand. But then hmm. Yes, Mr. Goswami, what do you say? Huh? That is. He's not only uploading photos, he's morphing and uploading photos. This is sending a very bad signal. Uh, can we have it on the 5th? Still trying to see. It is no, it is because only because of that we are not allowing anybody in the first week of January. We are too full. Yet we are trying to drag it to first week. Only looking at his age. They have already failed in their duty. How do we trust them? No, true. For this length of these two offenses, it is done. But we also have to see that there is no chance of him doing it again. But with the mentality he has different fake accounts and not the usual photographs. He's using morphing of things. It is too long. Hmm. Yes, Mr. Goswami, we can have it on the we can call for the CD on the 8th. What about the interim? Huh? Huh? Allegations are serious. Uh, we'll put it on the bailer to ensure that he has no access to any social media, any internet thing, and he could not be in contact with any of the victims or any witnesses in the meantime. On the 8th, we will reconsider the issue on the basis of the CD. Can it be done? Will the bailer has to ensure that he will not have access to any sort of internet in the meantime till the 8th. Do we agree to that? It has to be the bailer who will ensure it. One access and the bailer loses the. We will reconsider the issue on the 8th, whether he should continue or not. Only thing is 22 years old. But Mr. B.K. Mahajan, learned counsel appearing for the petitioner, also heard Mr. Goswami, learned PP. The allegations in the FIR is that the petitioner had uploaded fake Instagram, had opened fake Instagram account in the name, in certain names, and had posted for morphed indecent photographs of the daughter of the complainant and another person. Step. The petitioner, aged about 22 years, has been taken into custody on 5/12/2025. Full stop. Although the CD was called for by the Oh, no, the time was taken, huh? The earlier date, no? It was not called for. Call for the CD. The, Mr. Mahajan has submitted that the petitioner is undergoing education and and uh, and the mobile phones by which it is suspected that the Instagram accounts were used have also been seized. Mr. Mahajan has submitted that under the petitioner would undertake not to indulge in any social media activities if he is allowed an interim bail till the arrival of the CD so that he may continue with his education in the meantime. Stop. In view of the submissions make need and in view of the allegations and in view of the documents annexed to the bail petition, this court in the interim till 8th of January 2026 directs that the petitioner be released on bail on furnishing a bond of rupees 15,000 with two sureties of the like amount, comma, uh, one of which shall be a government servant, and at least one of the bailers shall assure that the petitioner would not have any access to the internet or social media during the time of protection being granted till 8th of January 2026, full stop. The the surety and the bail bond shall be to the satisfaction of the CJM Morigaon. Stop. Petitioner shall also not contact either the victims, their family, or any other witnesses, and shall cooperate with the investigating authority to divulge the investigating authority in the investigation, full stop. Any violation of the aforesaid conditions, or if any involvement of the petitioner is found in any social media during this period, comma, the bail shall be liable to be rejected at the once the if the same is brought to the notice of the court. List again on 8.1. Yes. Mm. We'll arrange for that. Of mm. Plenty. Okay. They refuse. Okay. Let's see. Okay. Uh, has to be after Bihu. Huh? It has to be after Bihu. I heard Mr. So-and-so and a counsel appearing for the petitioner also held the at APP. The petitioners, the three petitioners have been arrested in connection with recovery of commercial quantity of contrabands. Full stop. Call for the case diary. The counsel for the petitioner has submitted that the petitioner number 3 is suffering from serious illness. However, the authorities in custody of the petitioner number 3 has not given the medical documents and have not given the medical documents of the petition number 3 to the family of the petition number 3 to arrange for adequate medical attention, full stop. It's provided that if the family of the petitioners, petition number 3 approaches the authorities, they shall immediately provide the copies of the medical documents, copies of the documents relating to the medical attention being given to petition number 3. List on. We'll have it on the 20th. 20. 20. Yes, sir. 21. Hmm. Hmm. Uh, who was released? The He has been released. Huh. Huh. It was recovered from the 3 persons, and they were going to deliver it to you. Huh? Where is your forwarding? Where is your forwarding? Huh? Acha. Habitual offender. We'll have to call for the CD. How many more cases you have? First week is gone. Accommodate on 22nd, huh? When was he arrested? 35 days. 25 more, huh? 8th. 8th. 8th of January. Issue notice to the respondent number 2. The rest you can write now, the top part. Mr. So-and-so, remember? Issue, this is a matter which involves the provisions of the POCSO Act. Issue notice to the respondent number 2 under the prevalent instructions. Under the prevalent instructions, call for the TCR list on call for the TCR. After that, you write down this part. Huh? Call for the TCR. Scan copy of the TCR in connection with special POCSO case number 20 of 2020, pending before the learned special judge Lakhimpur. List again on 21st of January. For some time. Ah, yes. Huh? Hmm. CD call for 13 days. 20, 21. 21. 22 cases have already been fixed. That week we cannot. Before Bihu 9th. Call for the CD 9th of January 2026. Yes. हाँ हाँ. Recovery from? Recovery has been made from you. 22nd, huh? 22. 22 January. Call for the case diary. Ah, after some time. At learned counsel for the petitioner also heard the learned APP involves the provisions of the POCSO Act, issue notice to the respondent number 2 in accordance with the prevalent notification, call for the huh, is scan copy of the TCR list on 2nd of February. Twenty-ninth. 29th of January. Huh? Yes. Mr. Goswami, the minor goes missing for 5 6 days. There is no report anywhere. They do not say we were searching for her, we were doing this, we were doing that. No. What do you say? We are we are not on that. We cannot have love affairs with 14 years, 2 months. Huh? Decision 4-4 forcibly kidnapped my daughter, took her to so and so place. From there to Mizoram. Mizoram, you need inner line permits to go in. Sent to Mizoram with the help of so and so. Mizoram for 5 days. And this all the mother comes to know after 5 months that my daughter is being taken from this place to that place to that place and oblivious. Hmm? They took money from you. So there is no reason why they have why the FIR is delayed. What happened in the meantime? That Mm. then that 5 6 days that the daughter was missing, what action was taken? Eh? 8 12 25. Yes, I've read it. Hmm? Hmm. Where is it? Where is it? Ah, just a minute. This application is by whom? Accused is simply a brother of the principal accused and he is not. Brother of the accused. You really need to detain him. Huh? He's not anywhere there. Huh? Had the Learned Council appearing for the petition also heard Mr. Goswami. We'll dispose this of. We'll call for the CD. In the interim, we'll allow him. Huh? Also heard Mr. Goswami. The FIR reveals that the informant had lodged the complaint after 5 months of the alleged incident, where the brother of the present petitioner was alleged to have taken the minor daughter of the informant to Mizoram and held her captive there for around 5 days, and had assaulted her by tying her hands and legs also. Full stop. The Learned Counsel for the petitioner has submitted that the very delay in lodging the FIR by 5 months without any explanation as to what occurred in the meantime. Further, there being no explanation as to why the informant had not tried to trace the daughter of her own minor daughter during the 5 days when she went missing, etc., indicate that a false case may have been lodged. We have gone through the documents annexed to the bail petition, call for the case diary. We have seen that the present petitioner is the brother of the accused, brother of the person who had allegedly taken the minor daughter to Mizoram, etc. In the facts and circumstances, this court deems it fit to direct that the petitioner, namely Kausar Ahmed, shall be released on bail in the interim on his providing a bail bond of rupees 20,000 with two sureties of the like amount, one of whom shall be a government servant, subject to the satisfaction of this special judge, huh? Session judge. What? Session judge what? Session judge Sri Bhumi. Some stop. List again on 2nd of February. 2nd of February 2026, full stop. Issue notice to the respondent number 2 in accordance with the prevalent notification. The further continuance of the bail of the petitioner shall be reconsidered on the receipt of the case diary and appearance of the respondent number 2. Full stop. Yes. Mm. 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 Huh? From the police station, they've been arrested. Page 20. Hmm. Ah, husband. Yes. Huh? One statement in the police station. Why the custody? Hmm. Yeah, we are granting the bill. Bail granted 15,000. One surety of the like amount, subject to the satisfaction of the CJM Kamrup. So we'll put in the other part. Huh? Story part बाद में लिखेंगे. Hmm. Yes, the case involves the provisions of the POCSO Act. Accordingly, issue notice to the respondent number 2. And as per the prevalent notification, call for the TCR from TCR in connection with special POCSO case number 36 of 2024 pending before the learned special judge POCSO Sivsagar. Hmm? List on 28th. 28th to 8 January. 28th January. Huh? Hmm. This is a Mr. So and so. The This is an application under 483 BNSS for granting regular bail to the petitioner in connection with special NDPS case number 46 of 2025 arising out of Neelam Bazar PS case number 66 of 2025. Full stop. The quantity involved is commercial in nature. Call for the case diary. List again on when were you arrested? List again on 22nd of January or 30 January? 3rd of February. 3rd of February 2026. Yes. Hmm. He is driver come owner of the vehicle, not of the kettle. Okay. All issued 2 days prior to the kettle being transacted. Huh? Hmm. Arrested on 512. Yes, driver and owner of the truck vehicle. Heard Mr. So-and-so learned counsel appearing for the petitioner also heard learned EP. The gist of the affair is that the police had intercepted a vehicle carrying 5 number of cattle for which the owner and owner come driver of the vehicle could not produce the necessary challan. Full stop. The present application has been filed by the owner come driver of the vehicle who was taken into custody on 5/12/2025. Uh, we dispose it of or we call for basically do the petitioner has annexed the receipts of the cattle which he states has been obtained from the owner of the cattle. Stuff. This court is of the opinion that the continued custody of the petitioner is not required further in this case for investigation. In such view of the matter, the petitioner is likely to be released on bail on being 10,000 with 2 lakh of sureties, 2 sureties of the like amount subject to the satisfaction of the huh? And there will be a few other conditions which are usually there. He shall not involve in similar activities. Yeah. Bill application disposed of. Yes. Hmm. Huh? So is there uh, uh, this is an application under 483 of the BNSS 2023 in connection with dispute PS case number 895 of 2025. The allegations involve the provisions of the POCSO Act. Issue notice to the respondent number 2 in accordance with the prevalent notification. Call for the case diary. Placed again on 22nd of January. 22nd of January. Huh? 23rd. 23rd of January. But 23rd of January, you will have to come here and you will have to stand in the gate and then you will have to go back. 27. Okay, 27. Some maybe item 7. You take the steps, the PP will give it to him. The PP cannot represent him as of now as the informant. But once he says that it was done in my official capacity, I lost that FIR, thereafter the PP can take over. No difficulty. But he has to make that statement that it was only in my official capacity. Is it not? Yes, sir. Oh, yes, there was no. And you do not know regarding what case? Huh? Huh? No case registered. We'll close this. We'll record that. This anticipated bill petition had been filed by the petitioner apprehending arrest by the authorities of the Hatigao PS. It was stated in the petition that the petitioner was not being informed of any case being registered against him, yet he was required to report to the police station again and again, for which he apprehended an arrest without being informed even as to the case number. Full stop. Today, the learned APP has submitted that there is no case as of today registered against the petitioner. Full stop. On such submission, the petitioner prays that he may be allowed to withdraw this application with liberty to approach if the necessity so arises in the future. Anticipated bail petition closed. Anticipated bail petition closed with the liberty as prayed for. The instruction received by the learned APP is kept on record marked as Annexure X. Yes, sir. Huh? Hmm. Is it? No, দুজন ৰাতি অহা ফটোখন দিয়াৰ লগে লগে এইবোৰৰ পৰা আমাক মাতিম বুলি কয় বন্দুক আনি আর কি পলায়ন করে গতিকে মহোদয় কবি ইয়েস so he's a person who has got some authority over a government arms. Ah, so these people were, you want to say that these people burst crackers for nothing and then he got angry. That is what you're saying? That they used to just burst crackers, disturb him, so he came in here and then he will take out his gun and fire. Hmm. Where the was the gun fired? Arrested when 2210. FIR lodged on 8 days ago. 2210 till now. Till now, you have not arrested him. Huh? He's a government servant. Was allowed a gun. He's under suspension. Will not flee away. He'll give his statement. Let the CD come by then. We'll allow the interim because he's a government servant. Yes. IO has already taken your statement. Statement has also been recorded then. Huh? We'll believe him to that extent. Heard Mr. Swenson, learned counsel appearing for the petitioner, also heard the learned APP. The allegations in the FIR reveal that the petitioner who is a forest guard, what is he? Who is a grass cutter serving in the forest department, had uh, assaulted the informant and some of his friends when the informant had burst crackers to chase away elephants. Full stop. It is also the allegation that the uh, petitioner had fired two shots from his from the gun, from the government gun. Huh? Full stop. Gun of the forest guard. Full stop. The Pelana counsel for the petitioner submits that the statement of the petitioner had already been recorded on 22/10/2025 itself, when on the date when the FIR was lodged, although the incident had allegedly occurred on 14/10/2025. The learned counsel for the petitioner submitted that the petitioner is a government servant and there is no chance of his evading arrest or evading arrest, etc. The petitioner has also been placed under suspension. Stop. Following the incident. Full stop. The learned PP has submitted that the perusal of the case diary will be required since the anticipatory bail filed by the petitioner has already been rejected by the additional session judge. We have gone through the records next to the petition. Full stop. Call for the case diary list on 4th of February 2026. In the interim, it is provided that In the event of the arrest of the petitioner, he shall be released on a bail bond of rupees 20,000 with one surety of the like amount, subject to the satisfaction of the investigating authority. He shall not leave the territorial jurisdiction. He shall not try to influence any of the witnesses. Yes, sir. Huh? Huh? Hmm. Just a minute. She had filed some complaint and that was closed. Okay. Huh? Hmm. Hmm. They took the OTP. Hmm. Hmm. Ah. No money has been withdrawn. No money has been withdrawn. The RBI complaint has been closed, and the to his advantage where he gets a top-up loan. Yes, Mr. Goswami, usually to the bank authorities, we give the top-up, we give the OTP to login and all. So we'll call for the case diary, we'll let him appear. Mr. Hazarika Land Council appearing for the petitioner also heard the learned APP. The contents of the FIR revealed that the petitioner had sought for an OTP from the informant and being an employee of the Cholamandalam Investment and Finance Company Limited Guwahati branch, the said OTP given by the informant was utilized to close an RBI complaint, so that a top-up loan could be disbursed to the informant therein. Full stop. The learned counsel for the petitioner has submitted that the petitioner has already appeared before the investigating officer and his statement has also been recorded. He has appeared before the investigating officer on 13/12/20. Two petitioners have appeared before the investigating officer on 13/12/2025 to have their statements recorded. Full stop. Their mobile phones have also been seized. Full stop. Call for the case diary. In the interim, it is provided that in the event of the arrest of the petitioners, they shall be released on punishing bail bond of rupees 15,000 with two sureties of the like amount each. They shall not hamper and tamper with the investigation. They shall cooperate with the investigation, and they shall not try to influence the informant or any of the witnesses. 4th of February. List again on 4th of February along with the CD. Yes, sir. Page 16. Ah. Hmm. 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 Just a minute. Hmm. What is the quantity? 10.6 grams. Nothing recovered from his house. From your house, nothing recovered. Nothing recovered. Ah, yes, I was talking to him. Huh? Also, the material has been recovered from somewhere else after tracing out this man from his house. Hmm. Call for the case diary. Earliest date we'll try to give you. Ah, when can we have it, Mr. Goswami? Your convenience. Huh? 21-1. Huh? 21-1. Both, yes. 36 and 20. Both together we'll take it. Same FIR. Ah, just a minute. We'll finish up with 10 first. Uh, this is an application under 482 of the BNSS praying for pre-arrest bail in connection with Nazira PS case number 36 of 2025. So the allegations in the FIR are that although the person from whose house no, that the police had raided the premises of the applicant herein on the basis of specific information. However, the applicant could not be apprehended on the apprehension of one of the persons who was present in the house, and when he was later taken to the own house, certain amount of contraband in the intermediate quantity had been recovered from the house of the co-accused. All for the case diary list again on, when did you say 21? 21st of January. And the other one? Hmm. Ah, ah. Page number 14. Okay. This uh, this case along with AB number 3017 of 2025. Huh? I don't know. Yes. Along with 3012 of 2025, since the petitioners remain the same and is in apprehension that other cases have been lodged against him as per the FIR available in the earlier case. Let's stop this together on 21st of January. Yes, sir. Please, yes. Love apparently was not complete enough to not to go to the police station. Yes. Ah, ah, ah. What is the proviso you want? Oxo. এইখন ওপৰখন দিয়ক। ওপৰখন, এই সৰুখন। Hmm. What does it say? Where do I find our rules? Hmm. Yes. Proviso of, huh? Hmm. When was this proviso inserted? Huh? কেতিয়া proviso টো কেলে নাই ইয়াতে? Somehow our book does not contain the proviso. Huh? Does your book contain it? 2000? Sweet কথা. Hmm? A lot of questions will be answered then. It was amended in 2021 for 2018. Was your copy? From where that consent part has come in is 16 to 18 consent we have been. This will. If it has been removed, you do not know. You are not aware. Okay. এখন কেতিয়া? Yes, sir. I think we will have to take out the Gazette notification then. Eh, kindly find out. His book has his, our book does not have it. Huh. No, so we'll have to write down in the order that he has referred to this. Unfortunately, it has been amended. When we have to put it down? We have to put it down when it is not there. How come the consent under 18? Huh? Then we'll have it at 2. Kindly find out. Huh? If that is the new amendment, you are entitled. If it is not, then nothing. It will do maতিব. Kindly find out at 2. কিতাপখন দি দিয়ক তেওঁ। তেওঁৰ বুকখন কেতিয়া এডিশ্যন চাওকচোন, এডিশ্যনটো কেতিয়া? পিছফালে থাকিব। printed. Aye. Yes, sir. Oh. Why did you abscond? Why did you abscond? Petitioners are brothers and sisters. Huh? Tahir Ali. Huh? Tell us. I don't know. Huh? So what is your story? You had given it on rent. Huh? That vehicle belonged to you. Toyota Fortuner belonged to you, and you are not worried about where the vehicle is. Huh? Heard Mr. Swenson and counsel paying for the petitioner also had the learned APP called for the scan copy of the TCR in connection with it. In connection with to লিখি লো NDPS case number. Huh? Hmm. Test again on when do we have it? 4th. Earlier case? 4th of February. Yes, sir. Hmm. 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 He has a computer shop near the educational institution. They're uploading. No, the allegation is that he has uploaded it, or the allegation is that he has manufactured it. Hmm. The application will be done by the college inside the college premises. He is only a computer operator in a nearby shop, meaning that he is producing those mark sheets. He will not upload it. Why will he upload it? He will print it. We'll give the interim. Since we do not know, we will grant him the interim. He will appear. You confiscate his computers, find out whether he prints or he uploads. Let us know on the next date if he's printing the things, then it will be a different aspect. And if he was only involved in uploading what was given to him, computers will be with you. Yes. Heard Mr. D.P. Chaliya and a senior counsel appearing for the petitioner assisted by Ms. So-and-so. Also heard Mr. Goswami, learned APP. The FIR dated 19/11/2025. Any case, he has not been arrested till now. The FIR dated 19/11/2025 reveals that the principal of the Tongla College had made an allegation that 11 students had submitted forged and fabricated documents including mark sheet, income certificate, e-stamps, etc. to avail the benefit of the Ishan Uday Special Scholarship. Full stop. Mr. Chaliha, the senior counsel, has submitted that the petitioner is not in any way connected either to the students or to the college, and he has a computer shop near the college premises. Full stop. The police have been have been harassing him. The police have been visiting the shop, and therefore the petitioner apprehends that he may be arrested in connection with the aforesaid FIR. Investigation of the aforesaid FIR. Full stop. Call for the case diary. The petitioner is directed to appear before the investigating officer within a period of 7 days from today. It is provided that in the interim before the next date, if the petitioner is arrested, he shall be released on a bail bond of rupees 10,000 with two sureties of the like amount, subject to the satisfaction of the investigating officer. Full stop. The petitioner shall fully cooperate with the investigating officer, including allowing the examination of the electronic of the computer systems available in his shop, if so required by the investigating officer. Full stop. List again on by 5th of February 2026 along with the case diary. Yes. Hmm. 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 Huh. Huh. Not stolen exactly, smuggled property. Huh. He is one of the witnesses, one of the co-accused named in the FIR, because the person from whom the material has been recovered, he has taken his name. 40 drums in a bolero. Huh? The contents of the heard Mr. So-and-so learned counsel appearing for the petition. The contents of the also heard Mr. Goswami learned counsel learned APP. The allegations in the FIR are that the police had intercepted a vehicle carrying 40 drums of petrol and diesel, and on interception, the driver owner of the vehicle could not produce relevant documents regarding the loaded oil. Therefore, it was suspected that the loaded oil is stolen property, and on the end, the alleged and the accused therein has allegedly confessed that he transports oil from Bhutan and has named the present petitioner as one of the persons helping in running the said illegal business. Call for the case diary. List on the 4th of February 2026. Will allow him to appear. recovered. Hmm? No public from Bhutan who will come and complain here. Then we give it at an early date. We'll give it at an early date. We'll have it on the 8th of January. Hmm? Prayer for interim to be considered on the 8th of January. Huh? We'll consider it on the 8th of January. Let us see what the police have found against you. If you are doing international business, drums may contain something more. Next. Huh? Without? Yes. Show them the paper that this is where I bought it from. You could not have taken it out of the of your home garden. You have got it from somewhere. Show them the papers. Or give an additional affidavit saying this is the where the money, the petrol came from. Huh? Understood, but that person who was caught with it has given your name. We just want to see the CD as to what is it. We'll grant it on the next date. Nothing against you, we'll grant it. Rest assured. Yes. Yes, sir. Huh? Huh? Hmm. Molested, huh? Ah. Hmm. Why did your name come in the supplementary? Hmm. Your name is? Sir, he's nowhere in the beginning. Ah. Hmm. Identified, but he's not identified. Ah. The allegation is that she went to the park and then she was abducted. It turns out the I think the allegation is against these six persons were there. Hmm. They've been identified. Thereafter, first charge sheet does not contain him anywhere. Huh? Heard Mr. S.C. Biswas, learned counsel appearing for the petitioner, also heard the learned APP. The allegations leveled in the FIR and the charge sheet involved the provisions of the POCSO Act. Therefore, issue notice to the respondent number 2 in accordance with the prevalent notification. Call for the scan copy of the TCR from in connection with special POCSO case to page 2 ase, huh? Presently pending in the court of the district and session judge Kachar Silchar. List again on when can we have it? 30 January. Uh, any next, the charge sheet has been there, no, you have received the summons. When is the next date? 17th of January. 17th of January. 9th of January we can have it, sir. No, 9th of January we will have the matter fixed. We'll call for the TCR. We'll try on 9th. If the TCR is there, we'll try. Yes. List again on the 9th of January 2026. Yes, we can make that. Huge howl. Huh? Ah. Mm. Where was this? Nagaon. One person was apprehended. You are named in the FIR. Which one are you? T. Behind your house. Oh, Mr. Goswami, can we allow him to appear in the meantime? Huh? Huge recovery is very huge, 2000 rupees. And even one of the playing card is missing. Huh? Okay, heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard the learned APP. The allegations in the FIR is that acting on a tip-off, the police had raided behind the house of the petitioner and had recovered one plastic tarpaulin, two sets of playing card, and a total amount of rupees 2000 in cash, along with apprehending. Who was apprehending? Apprehending one person on the allegation of gambling. Full stop. It is alleged in the FIR that the other individuals involved in the illegal gambling had managed to flee. Full stop. The FIR names the present petitioner as the accused number 3. Full stop. The learned counsel for the petitioner has submitted that on the said date, even prior to the said date, the petitioner had arrived at Guwahati and was participating in a dharna proceedings. Full stop. Call for the case diary. List on 5th of February 2026. The petitioner is directed to appear before the investigating officer. In the meantime, If the petitioner is arrested, he shall be released on bail on furnishing a bond of rupees. You're only gambling for 2,000. How much can you? 10,000 two sureties of the like amount subject to the satisfaction of the investigate investigating authority on such terms and conditions as the investigating authority may impose upon the petitioner. Yes. Yes, madam. Eh? Hmm. The learned counsel for the petitioner has submitted that she apprehends an arrest in connection with an FIR that may have been lodged. Stop. Learned APP is requested to have instructions from the Boko police station as to whether any case has been registered against the petitioner herein, namely so and so, namely so and so, daughter of so and so. So list again on 9th of January. What protection would you like, madam? That is why we have called for the records from the uh, OC concerned. We have called for a report. In the meantime, how can we ask? How can we can give a pre-arrest bail or a bail in connection with a particular PS case number? Someone has to go to the PS and find out that number. Then we can consider it. Otherwise, we can only ask them if there is a case. Is it not? We cannot give a blanket protection. Some Ochut Rabha has lost some affair, is what the so and so is saying. What to do? We'll wait for the report. In the case, there are further communications from the Anay. It is further provided that in case the petitioner is required to participate in any investigation, the concerned officer in charge of the station shall inform the petitioner regarding the case number which he is required to participate in. Next time they give you a call, they'll give you the PS case number. Yes. 9th of January. Ah, ah, victim is a major. Then why the other part? For the gone 8 years, you are now being. Mr. Goswami, এজাহাৰকাৰী 20 বছৰ এতিয়া 8 বছৰৰ পৰা class since the age of class 12, eh? Since the age of 12 years. Notice has to go. And no, why the Ejahar after these 8 years? Hmm. Huh. Huh. Oh. Huh. No, false promise to marry is not we are what we are this with this abortion, objectionable photographs and videos. Huh? Then assault is also there, confining to a room, hitting the mother. Eh? Perhaps Bihu will be better. Huh? How is the mother is 50 years, 25 years. Yes, this sister and brother-in-law and mother, I think. No, when a 23-year-old, if we take it to be true, if a 23-year-old creates a ruckus in the house, 50, 25, and 27 cannot do much to stop it. We'll allow it for 2, 3, and 4. Huh? Heard the learned counsel appearing for the petitioner also heard the learned APP. The contents of the FIR have been noted. Full stop. The since it involves an allegation of the POXO Act, issue notice to the respondent number 2 in accordance with the prevalent notification. Full stop. The we have perused the contents of the FIR and we do not find any allegation of any allegation which may attract the provisions of the POXO Act against the petitioner number 2, 3, and 4 at this stage, since the acts have been alleged to have occurred around 8 years ago in connection with the love affair of the informant with the petitioner number 1. Full stop. In the above view of the matter, it is provided that in the event of the arrest, the petitioner number 2, 3, and 4 shall be released on bail or by furnishing a bail bond of rupees 15,000 each with one surety of the like amount. Should we go higher? 3 persons in the same family, 15,000 each, one surety of the like amount, subject to the satisfaction of the investigating officer. Full stop. Call for the case diary also. List again on 1st week of February. We'll have it on the 6th of 6th of February 2025. He was a minor, so again a juvenile. Those technicalities you take up on the next date with the CD, whether the subsequent acts have happened or not. Item 42. Yes, page number 10. Ah, hmm, 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 hmm. You were not found with the vehicle. is issued on 2 page 27. Can you tell me the date? It dangerously written, whether it is 2 or 9. Yes, owner of the vehicle and the owner of the 20. Hmm? Huh? Truck. Huh? And 12. Somehow they produce it and that cattle is bought just 1 day ago, 2 days ago. We notice a trend. The cattle is always bought 1 or 2 days ago. They have to go smarter. They have to grow smarter now. It allow them to appear in the meantime. Have your case diary. If the case diary shows something wrong, they'll produce the documents before the IO. The IO says they are fake or something. We'll relook into the privilege. Huh? Heard Miss So and counsel appearing for the petition. Also heard the learned APP. As per the FIR lodged on 10/12/2025, a Tata truck was intercepted by the police authorities of Jagiroad police station with 20 bulls. Full stop. On investigation. On inquiry, the driver and the handyman could not produce any documents, and thus there was a suspicion that the cattle were stolen and were being transported by illegal means and by inflicting cruelty upon the animals. Full stop. The learned counsel for the petitioners have submitted that this petition is being preferred by the owner of the vehicle, who is in no way connected with the procurement of the cattle, and also by the owner of the cattle, who has placed the different receipts of purchasing the cattle which have been recovered in the truck. Full stop. Uh, Call for the case diary list again on 6th of February 2026. In the meantime, it is directed that both the petitioners shall appear before the investigating authority in connection with Jagiroad PS case number 302 of 2025 within a period of 5 days from today. It is provided that in the event of their arrest, they shall be released on furnishing bail bond of rupees 20,000 each, with two sureties of the like amount, subject to the satisfaction of the investigating authority. Full stop. The petitioners shall produce all relevant documents necessary before the investigating authority and shall cooperate with the investigation that may take place in the meantime. Full stop. Further continuance of the privilege will depend on the investigation so far concluded, as reflected in the case diary list again, as stated before, as directed before. Hmm. 11/12. Gun. But What is the quantity? And what about other pending cases? Let the charges be framed. We'll have it in the last week of December, January. Let the charges be framed. Let the charges be framed, then we can consider. Huh? No, no, this is not enough time. We'll consider enough time later. Learned APP has submitted that the last date for the in the trial was fixed on 11/12/2025 for production. Full stop. He submits that since the charges are yet to be framed, comma, an updated status of the trial court may be called for prior to consideration of the bill petition. Full stop. Accordingly, list this matter again on the 27th of January. By which full stop call for the updated status of the trial in connection with this case. Yes, sir. Hmm. 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 I'm not being able to understand the language of the FIR at all. Was there some vernacular thing filed? Oh, the handwriting is also good. Hmm. Because they were repeated offenses, which he came to know later on. Yes, he was present in the house. He was present in the house. Sister is working outside. Someone snatches her away. He keeps on looking at the TV, oblivious of the world. It happens twice or thrice. Then the sister comes and complains. Let us not go into that. Hmm. Ah. Ah. Why would he do that? Why would he do that? Why would he randomly pick you to raise allegation against you? Hmm. Hmm. Ah. It escalated to this. Yes, madam. What does the TCR say? TCR was received. What does it say? Hmm? Oh, implicated, huh? I think we will allow her statement to be recorded. Ah, yes, yes. Ah. Hmm. 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 We would rather say it is a very honest investigation. Hmm. That is why we would consider this petition once the statement of the victim is taken before the competent court. Implicated you, where you were implicated. Therefore, we want to see what does he say before the trial court. She'll make a statement before the trial court. You would have the option of having a cross-examination. Once we have a look at that, some feeling in our mind whether you are or you may or may not be convicted. Is it not? It is at that stage we can consider it, sir. Are these not grounds for arguments in the trial? The arguments in the trial. What we are trying to see is whether there is a possibility of your being convicted, whether there is a possibility of your having done the act, and whether there is a possibility of you influencing the witnesses, right? The minor victim has not been examined. Once she is examined, there will be no possibility for you to influence her. We can consider. At this stage, can we consider? When is the next date? When is the next date? Find out, verify, we'll have it immediately after the next date, so that the statement of the victim, if taken, we can then consider. There's no other. Please, you come and tell us before one. Date to blank rakhibo. Date to blank rakhibo. The learned APP has heard Mr. Kadir, learned counsel, appearing for the petitioner, also heard the learned APP and Mr. Fukan, who appears as the amicus curiae, full stop. It has been submitted that the statement of the victim girl is yet to be recorded in the trial proceedings, full stop. The learned APP has submitted that that the consideration of the bail may be deferred to the time till the statement of the victim girl is recorded, full stop. Accordingly, list this matter again on so and so date, by which and also call for the scan copy of the TCR along with the statement of the minor victim recorded till then, full stop. You give us the date, we'll fill up the date. Evidence of the victim, deposition of the victim, deposition of the victim, statement to candidate, deposition of the victim. You give us the date, we'll fix it immediately thereafter. Service report was completed. Yes, it is complete. Still awaited, but he says it is completed. You have written instructions. Huh? After some time, if you don't have it, if you don't have the recent one, we'll have it after some time. Just find out. At 2? It at 2, huh? Hmm. This one. After. Oh, they're going to the scan copy. After some time. Publicly regulated DD. Yes. Hmm. 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 Right? Wow, what is the definition of slaughter? There must be a definition. Slaughter. Tell us what is slaughter. We have read in books that even humans can be slaughters. Yes. Hmm. Hmm. We had heard of that Hindi saying, "Kulhari pe pair marna." Here the buffalo is running to the X to get hurt or what? Someone hit it. Someone hit it. Tell us that you have not. Where is the calf? Hmm. You are which one? Accused number? Accused number one. Hmm. আঘাত করে। When were you arrested? 26th. Huh? 212. That calf was not recovered. You are doing agriculture in the government land. You have your own land. Hmm? Of government. Yes, we'll put some stringent conditions and we'll let them go. This heard Mr. Swenson constantly paying for the petition. I also heard the learned APP, the case diary as called for has been received. The He is the only arrested person. Others were also arrested. The petitioner was arrested pursuant to the FIR lodged on 25/11/2025 by the informant who stated that he had found one of his female buffaloes lying in a serious injured condition in the agricultural field of the accused person. The injury to the buffalo was found to have been done with a sharp weapon, and further, the calf of the buffalo was also missing. So it was suspected that since the buffalo had entered into the agricultural field of the petitioner here in Coma, they had assaulted the buffalo at the grazing land, full stop. The petitioner was taken into custody on 2/12/2025. Full stop. The contents of the CD has been produced. The facts in the facts and circumstances of the case, it is provided that the petitioner shall be. Now we deem it fit to grant the bail of the privilege of bail to the petitioner. According to the petitioner is directed to be released on bail on furnishing a bond of rupees 20,000 with two sureties of the like amount, subject to the satisfaction of JMFC Ajo. The JMFC shall be at liberty to impose such other conditions as may be required to ensure the participation of the petitioner in the investigation of the matter, full stop. It is further provided that the petitioner shall not engage in any activity, any other criminal activity during the period of bail. Add the other sections, other conditions also. Item number, next it is 6-1. We'll have to allow the scan copy to come. We'll have it on 19 or 20. 6, scan copy will be made on 7th or 8th. 9th, it will reach the court. Hmm. Probabilities we do not know, sir. Hmm. Who will intentionally delay? Make a prayer on the next day. Make a prayer there on the next day that my bail petition is pending because of the victim statement. The learned court will take into account. Huh? So therefore, we'll try to fix it on 20. That we cannot do. We will not impose that on the trial court, sir. That you have to make a request that they refuse, then we will see. Why should we impose the trial court as to whose deposition should be taken first? Mr. Mr. Kadi, Mr. Kadi, we are accommodating to the best of our Take an objection there. You show them the certified copy of this order that this is why my bail petition is pending. They cannot have it done this way. Have the statement, have the deposition taken for the victim girl so that at least other things proceed. That can be made by you before the court. It is upon the court to call for the witnesses in the seriality it wants. Is it not? Why the doctor first? Why not the victim first? Before or after? But we have asked for the TCR, scan copy of the TCR. It will not come. Any, okay, accommodated. 8th of January. 8th of January. এইটো ৰিফ্ৰেছ কৰি দিব দেই আকৌ পাছৱৰ্ড মাৰিব লাগে যে মনত 14 it was item 14 Mr. Kadir item 14 81 কৰি দি yes sir hmm hmm informant has been examined. Can we have a look at the FIR? Hmm hmm the victim 26/12 victim is 17 years. Hmm? Hmm. Just 1 minute. We'll just see one thing. Have you seen this? Hmm. Huh. Huh. Hmm. Huh. We have seen that. One thing we would like you to just go through. FIR bear reading shows that there was no relationship as on the date of filing of the FIR, perhaps. Some private photographs were taken, and the course was that you have a relationship with me. Have I understood correctly? Later on, I asked my daughter, it says above mentioned accused met my daughter frequently at railway station 20 days ago. Accused person went to meet my daughter and took mobile phone of my daughter. She disclosed that the accused person has some obscene photos in his mobile and forced her to marry with him or maintain. So and so, otherwise he will viral those photos. है ना? So till that point of time, nothing had happened is what we can assume. Hmm. Ah. So that is what we are trying. That is why we will go to that also. Oh, where is that? Where is it? Show us that. 10 competition. I think that statement before the judge has to be taken. Your petition, we'll see. Hmm? Let her statement be taken. Hmm? I have seen this, yes. Any particular sentence you want me to go through? When is the next date for the victim? 26/12. We'll try to have it on the reopening somewhere on the 7th. 7th with the statement of the victim. Huh? You remind us on the next date. If she does not come, we will hold it adverse against her to the extent that we'll get. Huh? Huh? After all this. Acha. We can assure you of one thing, that there will be very few parents who will assure each other that on attending majority will get them married. Let them roam around, and no parent does that. Parents say, let him be settled, then we will do it. Is it not? So these stories don't inspire much confidence in us. Huh? It was perhaps by stroke of luck that we had parents and we are also parents. So we know how parents react in these love affairs. We'll have it on the 8th along with this statement. Heard Mr. Swansea Learned Council, also heard the Learned Amicus Curiae and the Learned APP. Full stop. It has been submitted that the statement of the victim is yet to be recorded, while the statement of the informant has been recorded. Full stop. List again on 7th of January 2026, along with the statement of the victim recorded, if any, which is scheduled on 26th of December 2025. What are the certified copies that she is not appearing? Yes. Ah. Hmm. Is it weekly stock or fortnightly stock for him? Yes, sir. Presuming it is ganja and 3 kgs, then what do we do? Only on the FSL report, let us not put him to distress. If there is something which denies him the privilege, tell us. Hmm? It was recovered from you, and you were in a vehicle or what? Scooty alone. Any previous any more cases against you, sir? We will. Huh? Nowadays, they also go around to different districts to avoid detection. One Honda scooty field testings was conducted. 45 days. Intermediate quantity. Have you said you are a habitual person somewhere? No, no, the habitual consumer. Then that will help. Huh? Other persons is arrested on 511. Consider it. Consider it. Yes. Heard Mr. So and so learned counsel appearing for the petitioner. Also heard Mr. Goswami learned counsel, learned APP appearing, who has stated that the case diary has been received. Shall we say substantial progress in the investigation? The learned APP has submitted that although the other facets of the investigation has substantially progressed, comma, the FSL report is yet awaited. Full stop. The learned counsel for the petitioner has submitted that the quantity alleged to have been recovered is of intermediate quantity, and even if it is assumed that the same is ganja, comma, looking at the length of the incarceration, comma, the quantity recovered and the advanced stage of investigation, comma, and the petitioner may be granted the privilege of bail at this stage. Full stop. We have gone through the contents of the CD. We have also gone through the contents of the so and so. In the opinion of this court, the petitioner can be allowed the privilege of bail. Full stop. Accordingly, 15,000. Two sureties of the like amount, one of whom shall be. What is his age? Harali. One of them shall have permanent, shall have immovable property within the jurisdiction of the. Huh? Subject to the satisfaction of whom? Ah, oh, bail petition disposed of. Someone filed a wakalatnama today. You have filed it, yes. Ah, 5-4. Ah, hmm. Tell us. Objections. Ah, see? Does the informant even think about what is going on in that mind of the child who had to face those circumstances, and now the mother is proposing that I'll marry you off to the same person? Eh? What does the hmm, huh? The child already born. What stringent condition? They want to get married. I will put a condition that you will not go near the lady. What kind of a condition can I impose? Tell us what is the stringent condition. The submission made is that they are in love. Then the only person against that love relationship is now the court. We are saying don't go near each other. Yes, Mr. Goswami, what to do? She's what is her age now? A year more to go. How many more witnesses? Hmm? And arrested on? Hmm. He has come up with a bar for the. You're not satisfied with this kind of conduct. That is the problem. You are asking us to put stringent condition and you are saying that I will take care of the child. How can I allow both? We are being too lenient on this part. Hmm? Victim statement taken. Informant statement taken. Now she's 17. He does not object. Allow it in stringent conditions. We need to know what. Hmm? In this case, some mother and victim remained. Did not go by the FIR. Length of detention. Mother and victim examined. Wait. Yes, I heard Miss So and so. Sleeping for the petitioner also heard the learned APP. Mr. So and so has appeared for the respondent number 2, the informant who has submitted before this court that what you don't apprehend any risk. That he does not apprehend any influence or risk from the petitioner if he is allowed to remain on bail Full stop. Keeping in view the fact that the very difficult to give bail on these cases. Conscience does not allow. Bail of rupees 25,000, two sureties of the like amount. One should be a government servant, and at least one should have immovable property within the jurisdiction of the trial court. Shall not contact the victim or the informant in any manner whatsoever till the conclusion of the trial. Hmm? Put on the stringence of the condition. Yes. Hmm. মাতি দিয়ক না আপোনাৰ যেনেকে সুবিধা তেনেকে মাতি দিয়ক মানুহ যদি আছে মাতি দিয়ক মানুহ নাথাকিলে আফটাৰ সাম টাইম কৰি দিম let us speed up the process. Yes. Mm. 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 So that case where the education department will also be called in. Yes, madam. What does your this is off the record. We are not going to attach this to the case. But what does your department say? Huh? No. Why did the BEO go inquiring into a POXO matter? Issued to the BEO. It's good enough. Hmm? Charge sheet has been submitted. What do you want us to do? Charge sheet number to asin. You have the charge sheet number. He's giving you he's giving you a number and a date. Kindly listen to him. We'll argue on whether it is good or not. Huh? 2/12/24. Mm. Yes. Mm. Understand. We understand the vacation part. The allegation is against an headmaster by the school managing committee. You are for the school managing committee. In your politics, minor children are being involved, number one. Number two, the entire school atmosphere is gone. We will direct the lower court to take into account your statements made before. And if we are not wrong, last occasion, Mr. Gogoi had pointed out that some little minor cost can be imposed at around rupees 10 lakhs can be imposed on each of the persons involved who entered into this conspiracy. We'll take up the matter at 2 o'clock because now it is 1 o'clock. Have instructions from your client. This court is going to impose heavy cost on each of the persons. The person who gave lodged the FIR, the persons who instigated him to lodge the FIR, everyone will be drawn in by this court. On the 19th of January, possibly, we'll have the matter fixed before us with costs of around rupees 1 lakh on each of the persons involved. There'll be no sparing. When children are being dragged into situations of this manner, this character, we will not spare. Have your instruction set to what extent can they pay compensation to the headmaster? And let me tell you, whatever falls from your mouth, it is +3 from our side. If it falls as 2, we will make it 5. If it falls at 5, we will make it 8. If it falls at 0, we'll make it at least 3. It will be +3. Have your instructions. This kind of litigation, this court will not. We will make it sure that if it is a POXO matter, it goes to the logical end. You may not need to work any further. We will make life good for you. Yes. Without verification, you lost the FIR. You did not ask the parents to lose the FIR. You took it upon your shoulders. You took it upon your shoulders. Your shoulders are broad enough. You will ensure that you have broad shoulders to take all the burden. Not done. What situation? Their parents were not there. The children of the parents were not there. The parents of the children were not there. They were not there. So who was raising hue and cry? So why did they not lose the FIR? Why did you have to step in? Take some more pressure. At 2 o'clock, we'll put you some more. We'll put some more pressure. We'll see at 2. Hmm. 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 +3. I said +3. You have to give me an amount. +3. You have filed only your wakalatnama, or have you also filed any affidavit? You have filed an affidavit. We'll record all this. We will record all this. The charge sheet has been filed. Charge sheet has been filed. Very good. We will record that also. Okay. So now, since there is a statement made by the state, we will record that. We will record your submission on the same also. You would approach the trial court with a certified copy of the order that is being passed by this court. Since there is an affidavit filed before this court that it is a false case, the court has to take that into consideration immediately on your applying for the same. Have the matter closed. Pray for your compensation there. The cost will come here. Hmm? If you try to insist on that part of the issue, kindly listen to me. Kindly listen to me also. If you insist on that part of the issue, we will have to call for all the records. The matter keeps pending here. Understand the practicality of the situation. What we are trying to do is, because we will not distrust the PP. We cannot distrust, should not. Whether that information has been correctly sent to him or not is something that the trial court would have the records before them to see immediately. Your relief will be immediate. This may be a more suitable to the eyes, but the relief is more better there. The moment we record all this part, Monday, Tuesday, everything can be done with be done and over with. Mr. Gogoi, since the charge sheet has been submitted, as stated by Mr. Goswami, since the charge sheet is submitted, we are remanding the matter to the trial court. We are recording everything that has happened here. He would pray for a whatever there, that this is what the High Court has found and this is what the High Court record says. So far as the allegation that whether a charge sheet has been submitted or not, he says that it requires a signature of this magistrate and this and that. We will leave it open to the trial court to find out whether it was properly submitted, within what time submitted and what not. Those are matters of fact we need not go into to prolong the litigation. So far as his client is concerned, we are imposing a cost on him to be deposited here. And we will leave him at the liberty to agitate his grounds for compensation there. So far as the education department is concerned, we will take into account whatever you have placed before us today, and we would refer the matter to the secretary to see as to what are the things that a BO requires to do to have them apprised of what they should be doing. When allegations of this nature comes up, their duty is to report to the police. Their duty cannot be to have enquiries held. That facilitated this entire fiasco. That is why we have brought you here. If the BO had not interfered, in all probability, this lady would have not stood up to say that it is all false. So that is where we will also give you directions on that also. Where is your affidavit? Have you filed your affidavit? Page 21. Unfortunately, page 21 is not here. Did you have it called for? It is received. এবার চকচোন মই দেখা পোৱা নাই নে মই মোৰ হাতৰ পিনে one copy we will just need, but what happened to our copy is another question, na? এটা খবৰ এটা লওকচোন. Can we have your copy for the time being? For the time being, we will do with your copy. No, since this all has come, since all তেতিয়াহ'লে সেইটো মোটা আনিব লাগিব নেকি filing number? Mr. Counsel, can you give the filing number of the affidavit? Find out, give it to them so that we can have it tagged with the records. It has not come on record till now. Just find out. You file your application claiming compensation for everything, your suspension, your being behind bars, your defamation. What all can you claim for? Go for it. We will not be able to decide it here. So therefore, we are sending you back there. It will be quicker. Whose number? Para number? It is blank. Here it is blank. which has been filed. Huh? You gave whose number? Instead of the petitioner's number, you have put your number. Have it corrected so that it can be. Huh? You go there, you correct it, it'll come here. Take down. Ah. No, you will do this at the end. We'll pass the orders at the end of the board. That the others not suffer, we'll pass the orders at the end of the board. We'll have more time, na? বাকি কেইটা মাতি লওক তাৰপিছত এইটো কম। In the meantime, kindly correct that slip খন লৈ লওক, affidavit খন খুজাই দিয়ক। You go and correct it, we'll have the slip by that time, yes? Not necessary. Not necessary. We'll record your presence, not necessary. এটা আছে matter. For what purpose? Why is it being withdrawn? Other petitioners, not these two. Other accused. Achha. Legal counsel for the petitioner has submitted that he is under instructions to not to press this bail application in the present form. Full stop. He, however, prays the liberty that he may approach the competent court of law in case of further developments. Full stop. Bail application is allowed to be withdrawn with the liberty paid for. This you will find in most of the with most of the lawyers, this publication is there. We are not endorsing it, but somehow it gives the correct. Huh? Some other this. So we'll just issue notice on the respondent number 2. Had Mr. So-and-so learned counsel paying for the petitioner. Also had also had Mr. Goswami learned APP. Full stop. The allegations leveled against the petitioner involve the provisions of the POCSO Act. Full stop. Therefore, in accordance with the prevalent notification, let notice be issued upon the respondent number 2. In the meantime, call for the CD. List on. Huh? 20. 20 is choke full. Earliest is 27th. 27? We'll have it on 27, Mr. Goswami, on 27th. This notice on the respondent number 2 was who have received? Police has received, they have not received. We'll keep it on an early date for service report only. Perhaps you can keep it on 8th. 8th. The right ATP has submitted that the service, that the report of service upon the respondent number 2 is awaited, full stop, and efforts are on, full stop. Place this matter again on 8th of January with the service report on the respondent number 2. Hmm. 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 Already submitted. Huh? We will keep the previous bill alive till then. No, in any case, he will not be arrested by the investigating authority. There is no reason. Yes, yes. Ah, heard Mr. Huh? Heard Mr. So-and-so learned counsel paying for the petitioner. Also heard the learned APP. Miss So-and-so appears on behalf of Mr. So-and-so. Um, for the respondent number 2. The learned counsel for the petitioner has submitted that pursuant to the protection granted by this court by the order dated 19/9/2025. The petition has appeared before the IO and the investigation has in the meantime been completed. Full stop. The learned APP has submitted that the charge sheet has been submitted by charge. Right? Stop. The learned counsel appearing for the respondent number 2 has objected to the continuance of the privilege of pre-arrest bail granted to the petitioner. However, in view of the fact that the charge sheet has been completed, no further orders are called for in the present AB. Full stop. Petitioner at liberty to approach the concerned court for regular bail as and when necessary. The investigating authority has submitted the charge sheet. Why will he arrest you now? Is it within his hands to arrest you? No, is it not? If you receive this summon and you don't go, then you will face consequences. We will not protect you then. Dear, disposed. Hmm. Ah, yes. How can he appear? He was taking treatment for gunshot wounds. Ah. Hmm. 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 So your FIR has also been registered now. It has been registered. That was already called for. Case diary with the connection with the other cases here. No, no, there are two cases. So in the case which was registered against the petitioner, you have the case diary. Where the petitioner lost the FIR, that case diary is not before you. He is praying that that case diary may be called for. In the meantime, he is in Max Hospital. We had granted him interim protection for treatment only. In connection with treatment, he has gone to Max Hospital. Please, 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 please. Hmm. 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 He could not give his statement. He has vanished. Where is your discharge certificate from the other hospital? From where you were taking the treatment? No, no, I want the discharge certificate. Please ask for it. We'll have it after 10, 15 minutes. Ask the client to send you the discharge certificate. Huh? Ask them to send the discharge certificate. We want to see what was the result. Because Mr. Goswami, one thing that has just come to our mind is there is something called against medical DAMA, discharge against medical advice. That is simply written as DAMA in the discharge certificate. Without any reference to anywhere, they will simply say, this is what we have done. Case of DAMA. That is discharge against medical advice. If that is there, then maybe for better treatment they may have gone. We may come to some presumption. But if it is said that home rest will do, then rushing away during investigation is something we may not appreciate. Have your medical certificate called for? The discharge certificate from the hospital at where? Sipat? Here, na? Just get us a copy of the discharge certificate. You get it on WhatsApp, you get a printout. Huh. That is why we want to see if it is a DA. Maybe he has shown us some photographs. Undergone the surgery is not in doubt. Whether he was, you give me that discharge certificate. Just give me the discharge certificate. We will understand what we have to. Yes. Next, deduct 20. Hmm. Huh. Hmm. His petitioner. Huh? 8,30,000 is recovered from the brother. Brothers will live together. Brothers will live together. That may not, we may not hold against him. No, lots of. Ah. Hmm. 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 This of the FIR at page 10, FIR at page 10, that was lodged by the police. SI. Even in the forwarding, hmm, you stay with your brother in the same house. What do you say your brother is naming you to the police? Ah, so the machine, the only statement against you is from your brother. FIR doesn't say so, forwarding does not say so. It is only your brother. And then the brother says that you are involved. That is the problem. From what he has said. Just recovered from your room. All these duplicate things. Hmm? Hmm. Hmm? With a protection, everybody is ready to cooperate. The recovered from your room, your brother taking your name. We will have it after the Bihu break with an updated CD. Or public money is being misused. Identities are being misused. It seems very small here. Sitting here, it seems very small offense. And those are 400 rupees. But what happens is families get ruined. People's identity gets stolen. So let them have an updated CD when your brother may change his mind. That is what the CD says. The brother names you, we are helpless. List this matter again on 31/2026 for updated CD. 31, not 31. 31. 30. Yes, sir. appointed the amicus. Yes. Hmm. Okay. But the amicus can still assist us. Why not? Yes, sir. Ah. Hmm? We went through it, and we also went through the statements of the other persons whose statements were recorded. Yes, sir. What do you want to say? Hmm. It may not be a correct allegation. Hmm. 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 You said three. Hmm. Ah. Okay. Hmm. Hmm. It remains with you. No difficulty. Hmm. We will not comment on the merit of the case in any manner whatsoever in the order. Huh? Hmm. To whom? Sure. Hmm. We. Hmm. Hmm. Then can this court say that without serving that 35 notice, the investigating officer will not arrest him? It is little do for you. Yes, madam. A little help from you. I do not know whether you have gone through the other documents. As an amicus, you would be able to all, and also whatever the statements were recorded by the. Our initial impression was more than the child is being churned to an extent that she is now a swing on what to do. Because of the parents' attitude, we are not saying that either of the version may be false. We are not on that, or we are not alleging anything on the child. But apparently, it is becoming very hard for her to come to a decision as to what I am supposed to do now. The child, as a child, what is she supposed to do? She is doing whatever she is best finding to her, understanding whatever she is thinking is best. Now, there are statements of other people who were there present, including ladies who are of good age and whom, at least in a civil society, one would have thought would have raised an issue if something came to their notice in any party, be it with any child. We did not find such allegations reflecting in their statements. Now, of course, it is true that the child might have suffered some uncomfortableness because of the behavior of one of the persons there. For that, we would perhaps require something more to say that he should be behind bars at this point of time. That is what we are tentatively thinking. Whether the custodial interrogation would be necessary and whether, on basis of what has still now been collected, there is a chance of his conviction or not. What do you say on that? Hmm. There is no bar. There is no bar. Ah, anything else? All sorts of conditions on not only the we will not go to, this is not by the father, this is by the uncle. So we can direct the father to ensure that other persons do not come into her contact or into her contact unless she wants so. That sort of a thing has to be an understanding. But initially, Pokso, we are not statements which we have read from the with the help of the PP doesn't appear that something of that extent had happened. Because not even the daughter, not even other people. We have seen 65 years old, 60 years old people saying that they were in front of us and nothing of that sort had been, had it had gone to that extent. To some extent, we also have to believe the society. We will grant him the privilege. We'll grant him the privilege. Let the investigation be complete. You have not appeared till now. You have to go and appear. You have to have your statement recorded and whatever it is. Yes. Heard Mr. Also heard the learned APP, heard Mr. So and so, heard Madam so and so. He would appear for the respondent number 2. Madam would appear as the amicus appointed by the court. The allegations against the petitioner are reflected in the FIR dated 11/10/2025, where the minor victim has alleged that the applicant herein had misbehaved in a manner which has been reflected in the FIR with her during a party which she was attending along with her father. The learned counsel for the petitioner, by referring to the different documents annexed to the bail petition and also to the additional affidavit file, have has stated that there is an ongoing feud between the mother and the father of the alleged victim child. And uh, although it is a fact that they had all attended a party on the particular night of 10/10/2025, no such incident had happened, and that this FIR has been lodged only with a view to uh, has been lodged without such happenings, without any such incident happening, full stop. The This court had appointed the amicus in the absence of representation by the respondent number 2. However, today Mr. Swenso has appeared. The learned APP has produced the case diary related to the incident, and from the investigation conducted and the statement of the witnesses so far recorded, this court is of the prima facie view that the petitioner would be entitled to the privilege of a pre-arrest bail under strict conditions, so as not to hamper or temper the investigation in any manner, full stop. In such view of the matter, it is provided that the petitioner shall appear before the investigating authority within a period of 7 days from today to have his statement recorded, full stop. In the event of the arrest of the petitioner, he shall be released on furnishing a bond of rupees 25,000 with two sureties of the like amount, subject to the satisfaction of the in of the arresting authority. Full stop. The the bail of the petitioner shall also be subject to the following conditions. Pokso wala condition kuch लगाना पड़ेगा. It is made clear that the present present privilege of previous bail has been granted on a prima facie view of the evidence so far collected. And in case the petitioner violates any of the terms and conditions, or if any further material is collected by the investigating officer, the investigating officer shall be at liberty to bring the same to the notice of this court, whereupon further continuance of the privilege would be reconsidered. Anticipated bail petition is disposed of. Anything you find, you come back. At this stage, even if you have a difficulty, you come back, we'll look into it. I don't, sir. Please give it to us. This is item 17. Ah. We will do that, but we just wanted it. It is another matter. It is not his matter. Oh, are you an interim or something? No, it's a BA. Grounds of arrest has not been communicated. Uh, it has not been communicated to you at all. Where is that? What was given to you? Can you show us? Is it here, part of the record? No, 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 no. You received something. Have you given it before this court? Only the arrest memo. Page 30. We are not putting you to any uncomfortable situation. Let us go. Page 33 is what? Arrest memo. Where is the forwarding? What had happened? Hmm. We have to give him one opportunity to just go through the records to find out. Otherwise, it doesn't seem to be complete. Before we interfere, on 5th. Huh? Yes, 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 please. Hmm. Learned counsel for the petitioner has submitted that only a minor quantity of 115 grams of heroin has been recovered from the petitioner. He has further submitted that the petitioner was not given the grounds of his arrest at the time prior to production before the remand magistrate, full stop. The learned APP has submitted that the records received are voluminous and he may be accommodated only for today to go through the records. List this matter again on 5th of January, by which time the learned APP cell go through the records and inform the court regarding the submissions made on behalf of the petitioner. List on 5th of January. Item? Huh. Yes, yes. The medical certificate is there. Can I have a look at it? Why did he run away? He should have gone and got his statement recorded. Ah, uh, just a minute. We'll first go through this. Hmm? A file to the item. This was item 21, huh? Rib fracture, diaphragmatic injury, left side through and through stomach injury. Injury to the body of pancreas, injury to left kidney, bullet at back below subcutaneous tissue line. Discharge this and this, vital stable, regular use. Stitch removal on 14/12. Yes. Huh? The hospital admission slip. What is the critical condition? Hmm? So when we passed the order, we said that if your hospitalization is no further required, in case your arrest is necessary, you are under hospital, they will not arrest you, they will give you bail on whatever conditions we had given. In case your hospitalization is not required, they will inform us. We did not give them the liberty to arrest you right away then and there. What happened in those 2 days that you had to go away from here? Huh? So they did not arrest you. You were discharged. Mm, mm. Nowadays, the lesser said about admissions in hospitals, the better. We appreciated the medical condition of the petitioner, and therefore we had said that they will not disturb you at all during your treatment. All that was required to be done was to tell us that yes, in the meantime, next date fixed is today. In the meantime, in case the petitioner is arrested, he shall be released on furnishing a bail bond. All he had to do was furnish a bail bond. Thereafter, if further hospitalization is not required, we will be informed. We would have taken a call today. In any case, they would not within a day or two travel to Delhi to perhaps pick you up and bring you back here. The best we can do is we can withdraw the whatever order was whatever privilege was given to you. You come back and apply again. Tell us. Hmm. True. Hmm. Yes. Take down. Heard Mr. So and so learned counsel appearing for the petitioner also heard the learned APP. By the order dated 12/12/2025, this court had directed that the petitioner, in the event of the arrest of the petitioner before today, he shall be released on furnishing a bail bond of rupees 25,000 with one surety of the like nature, subject to the satisfaction of the investigating authority. It was further provided that in case the investigating authority finds that the petitioner does not require hospitalization or specialized care, the same may be informed to the court today. Full stop. Today, when the matter is called upon, the learned counsel for the petitioner has submitted that the petitioner has left for Delhi for further treatment of the wound. The learned APP has produced the case diary which contains the discharge summary of the petitioner, which shows the the vitals of the petitioner at the time of discharge, the vitals were stable and on full stop. The petitioner was required to review after 14 days in surgery, OPD, or if necessary in an emergency, full stop. Stitch removal was scheduled on 14/12/2025. The APP has submitted that the petitioner had left for Delhi without informing the investigating officer. Full stop. The Learned Counsel for the petitioner has submitted that the requirement of the petitioner to move to Delhi was in an emergency and therefore they had failed. Full stop. The Learned Counsel for the petitioner has further submitted that the FIR, which was, where is that? Which was which was lodged by the petitioner's wife on 4/12/2025 has been registered as a police case on uh, on 12/12/2025. Full stop. This court fails to understand as to under what conditions the fails to understand as to under what conditions the petitioner had to leave the jurisdiction of the investigating officer even before the matter was relisted before this court. Full stop. The court also notices that the discharge certificate does not indicate that the petitioner would require such emergent intervention, medical intervention. Full stop. Nothing has been placed before this court to show that the petitioner had to be moved away in an emergency. Full stop. It is therefore, this court therefore is of the view that the petitioner has exceeded the privilege which was granted to the petitioner. Full stop. At the fervent request of the Learned Counsel for the petitioner, the Learned APP is requested to procure a scan copy of the case diary with regard to the Kharupetia PS case number so and so also on the next date of listing. Full stop. Since the petitioner has already left the jurisdiction of the investigating officer without obtaining the bail, without obtaining the privilege of bail as granted by the earlier order, this court does not deem it a fit case to continue the said privilege for the time being. Full stop. Further orders as will be required would be passed on production of the case diary in Kharupetia PS case number so and so. List the matter again on 9th of February 2026. Yes. You have already gone beyond their jurisdiction. What can we do? Huh? I have said that I am not continuing the privilege of the earlier order. Yes. What did he? Yes. It is further submitted by the Learned APP that the gun which was used in the incident is a country-made gun. Which is not a licensed gun, I suppose. And the FSL report for the said gun is also awaited. No, what do you expect from this court? We are nowhere on the merit of any of the allegations. We had granted a privilege. We do not write an order saying that I am granting him bail. I have always written I have granted you the privilege of a bail. Is it not? This privilege being granted to you was on the condition that you will not be arrested till 19/12/2025. And in case further hospitalization is not required, the investigating authority would inform us. The man goes away from our jurisdiction, the investigation officer's jurisdiction, everybody's jurisdiction. He wants to flee. So let the investigating officer chase. We have not recalled that order. We have simply not continued that order. On the next date of listing, show us that you required a hospitalization in Delhi. I assure you, if this court is there, we will reconsider extending the same order. But at this stage, we do not find the bona fide of the. Till then, we are discontinuing it. Once it comes, we may continue it. No, no, no. He should not have left the jurisdiction. Sorry. That would have been continued. I'm telling you here, sitting here, that would have been continued even if he was released from the hospital, if his statement had been recorded and he had cooperated with the investigating authority. His mode of going beyond the long arms of law. Yes, next. Yes, sir. Short matter, long matter. It will take some time. The trial court records have been received. The counsel for the petitioner praised the matter to be fixed for hearing. Accordingly, list the matter again on the 3rd of February 2026 for hearing. You have any interim protection? What about the service on the other part? Okay. And none appears for the respondents today. Full stop. एकदम ऊपर लिखिएगा ना. So and so appears for petitioner, so and so appears for the, none appears for the respondent. TCI has been received. Makes a prayer for picking up the matter for hearing. February 3rd. 25. Yes. Collecting what? Parking fees. Yes. And you are Unfortunately, we are only seeing black and white here. Anyway, that is not necessary. We are awaiting service report on the respondent number. Mr. So-and-so appears for the petitioner.
Lordship, I beg to appear
Yes.
for the petitioner.
Since we cannot see you, you have to request for only a hearing. The appearance, we have to say sorry. Yes.
No, I was not sure whether I'll be heard even, but I'm glad that I'm
Yes.
at least being heard.
Ah.
The service is awaited, and Your
Hmm.
Lordship, it's a case which Your Lordships will have to hear.
So we'll await service report. List it in the third week, in the first week of February, 5th, 6th, something.
Can it be 11th of February, subject to convenience?
It's already, you have a interim order in your
Yes,
favor.
interim order is there already. I have no difficulty. It can be.
We will have it on the third, in the first week of February. Because
No
January again, on the immediately on the reopening, we'll be fixing matters for the bail and the anticipatory bail matters in the last week of January. We have to keep some space for that.
No difficulty, Your Lordship.
So we'll have it on the 4th of February. 4th of February is okay?
Not 11th, if it can be.
11th of February, yes. The service report on the respondent number 2 is awaited. So and so appears for the petitioner through video conference, and Mr. So and so appears in the court to assist him. Await service report list again on 11th of February 2026 along with service report.
Interim order may be continued.
The interim order passed earlier shall continue. Interim orders passed earlier shall continue till disposal of the matter.
Deeply obliged, Willard.
Until further orders disposal na until further orders interim order to continue until further orders. Yes, sir. Huh? Huh? Where? In the event of his arrest prior to 19/1/2026. Huh? Hmm. 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 Learned session judge, we agree to. Our intent was that you will appear on or before 19/1/2026 whenever you want to. Listen to us. If you appear on the 2nd of January, you will file an application for regular bail before the learned session judge. If you appear on the 19th, you will file your application for regular bail on the 19th. All right. In the meantime, any day before prior to 19/1/2026, if you are taken into custody, then the arresting authority will release you so that you can go and appear before the learned trial court and again pray for your regular bail. That was the intention. What is wrong here? Huh? Huh? Condition 3. Huh? Huh? Charge sheet has been filed. Huh? No, he wants to say that at page number 12, at the last line we had written that if he is arrested in connection with the case, then the arresting authority will release him. What he now wants to convert this order into is he will go and appear before the session judge, and in the case of his arrest, even then the trial court will immediately release him. Therefore, we will take away the jurisdiction of the sessions court because he's already under bail from this court. The order from bail is from this court. That was never the intent, sir. Cannot. They could not have arrested you. You had to appear on your summons. Have you received the summons? Now you go and appear. And prior to your appearing before the summons, if any arresting authority arrests you, whether it be on an NBWA, whether it be on anything, he will immediately release you so that you are allowed to go and pray for regular bail before the sessions court. Is our intent clear now? Now the language is clear. We will not pass an order where we will give you the liberty to appear before the sessions court on 19/1 and then show an order saying that, look, sir, High Court has asked you to give me the bail. You cannot refuse. Please let me go. That liberty we are not giving. That has been a long thing we have been hearing for a long thing. Take an order from the court, place it before there, take your bill. Whether you will appear or not, God knows. That is what we want to stop. Misuse of our orders. Huh? No, sorry. What do you say? Misunderstanding of our orders. We want to stop that. Let us not do that. Yes, we have allowed you. 19/1/2026, prior to that, you will not be arrested, sir. Any arresting authority on any authority of law, we have not even named the case C. We have taken care that we have not even named under which case. Even if in some other case you are being arrested, you will be released on bail. because he cannot arrest you. And then you will rush to the sessions court, submit to the jurisdiction. We want the sessions court, the magistrates court to feel that people submit to their jurisdiction for bail first, that their summons have some meaning. Don't appear for 5-6 times, let an NBW come, we'll go to the High Court, get a bail, come, appear, and then it is delayed by another 7 months. We will not allow that. This court will not. We will simply say, you go, you appear. Prior to your date of appearance, you will not be arrested. Now, to keep you in custody to face the trial or to allow you to be on bail is the complete discretion of the trial court. If our order is understood in that meaning, we are not interfering with it. If you try to say that this order does not mean what we are saying, then we'll make all necessary corrections to mean that. The petitioner shall be at liberty to appear before the learned session judge even prior to 19/106, 2026. Go tomorrow, file your regular bail petition. You'll be on bail. Don't want to take the risk, appear on 19. On her appearance, she will be released on bail. Then have we left anything for the session judge to do? The moment I say on your appearance before the session judge, you will be released on bail. Have I left the discretion to the learned session judge whose summons you did not answer? Is it not? Show us here that the summons were received after the date fixed. We will grant you the bail now. Show us you received the summons at a stage where you could not go and appear. It was impossible for you to appear. We will grant you the bail now. We will ensure. Then did not go. Next date. Next date has to now go. When we are trying to say that the petitioner has the technical right under 22(1), when we go to that technicality, we will remain this technical. Why? Move a revision petition that I cannot be called an absconder. Move it. 5th, we will give you that order. Absconder deleted. Sessions court will try the bail application, will hear the bail application of the petitioner on merit without for once considering him to be an absconder. We can record it here, yes. There, while considering the bail petition of the petitioner on his appearance, the trial court will not be influenced by the classification of the petitioner as an absconder in the charge sheet. We'll record that. That is the law. Police cannot declare you absconder. If I'm correct, yes. This long discussion only because we are hoping that some other people will hear it and understand that those kind of orders will not come. Bail, you are summoned by a particular court. Bail, that court will consider. We will not interfere in their jurisdiction. He will be arrested the moment he appears. That is your fear. Let him understand, let one person understand, let one person be an example that not responding to summons can be fatal. So it has to start somewhere, sir. We don't have anything against either the petitioner or you can. We don't want to. We don't want to. We don't want to take away the jurisdiction of the. Should we? That is why people have now started to not to respond to the summons on the first 1 or 2 dates. That has to go. Court summon is a moilu etia. That has to be the attitude. Dignity of the court is to be held higher than the fear of a man. So withdraw or dismiss. We are not giving that handle. Not in this case, and let me Any other cases have I given that order that he will not be he will be released on bail on his appearance? Any order? We have set aside a lot of NBWs. Lot of NBWs we have set aside. On the first motion day, we have not even heard what was the issue. We have said you will not be arrested till the next day. Go appear, pray before that. You disrespected that court, pray for respect from that court. Hmm, 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 hmm. Is it binding upon us? In situations we have done so. In situations we have directed that the Zima petition will be moved before the trial court, and the trial court will release the vehicle. Have we not said that? We have said that. Accused will appear before the trial court will release the accused immediately. We have done that, but not a case where we can consider that. Hmm? Yes. That is what we do. That is exactly what. No. This is because he was shown as a absconder only. He did not defy the summons. This order does not show that he defied summons. Shows something that he, despite receipt of summons, the person did not appear. Yet this court said that yes, I am granting you bail. That is not there. The defiance of the summon is what we are against. One court sitting there from morning to evening. Please come, please come. We'll get it from the High Court. Will not do. Withdrawn. Learned Counsel, Mr. M.R. Khandakar, Learned Counsel for the petitioner, after arguing the matter for quite some time, has submitted that this petitioner may be closed as not pressed. Stop. This court clarifies that the petitioner has shown interest in appearing before the trial court to face the trial proceedings, and the fear is that being declared an absconder, the prayer for regular bail placed before the trial court on his appearance may be influenced. Consideration of the prayer to prayer for no consideration of the prayer for regular bail may be influenced by the aforesaid fact. Full stop. This court clarifies that the declaration of as an absconder in the charge sheet would not in any manner affect the consideration of the bail petition to be filed by the petitioner before the learned trial court on his appearance on 19/1/2026. The learned trial court shall also consider the fact that the petitioner has expressed his willingness to participate in the trial, subject to all such just conditions as may be imposed by the trial court upon him while deciding the bail petition. Full stop. The prayer of Mr. Khandakar to withdraw the petition is allowed, subject to the observations made herein before. Made it as easy for you as possible. Yes. All those things written will help you. Is it not? That the court wants to give it to you, but does not want to give it to you. Ah. Hmm. 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 No, in this particular case, we have said that it should not be done. In this particular case, it should not be done. He had a summon, he did not appear, so he wants now to appear. Hmm. Hmm. Yes. At least at least we are making an effort to the best of our understanding that the trial court or the court of remand has to be respected. It has to be respected as someone of the court. From what we have seen in, we will not say which, but in some of the countries, one notice ruins life. It ruins the entire life of that person. The the fear of the court calling you ruins life. It should be respected. We do not say the court should be feared. It should be respected. If I am called, I attend and I will have justice there. That should be the attitude. So we will only expect justice to be there and no respect. Oh, that cannot be. One or two persons will try appearing, then the rest will try to, at least to our understanding, everybody will try to then respect, go, appear. No one wants to keep the jails full. Your and my money trying to feed them. Who wants the jails full? No one wants. We want to send them all home. Save some money, have better roads. Huh? কি গ'ল কিবা আৰু? Yes. Do you really want us to strike out the whole order and say you want to withdraw and finish it? Or should we let it remain that you have shown your indulgence? Yes. এইটো কি হয়? Mr. Goswami wanted some time to go to the TCR by some criminal petition. Admission এটাই আছে ন?
Please, Jildo.
Yes, sir.
My lord, in this case, we are appearing as legal aid counsel, my lord.
Okay.
My lord, by filing the revision petition, my
এইটো
lord,
কি হয়?
we have assessed the order.
Are you under an interim protection, sir?
No, my lord.
Okay. Yes, tell us.
I arrested, my lord, on 9/5/2024.
TCR আহিছে ন?
Since then, my lord, I am languishing in jail. My lord, in the meantime, my lord, charge sheet submitted, trial started, my lord. And the learned trial judge, my lord, on the day of framing charge, my lord, heard the parties. The accused petitioner, my lord, he filed an application before the learned trial judge for, my lord, discharging him from the charges because our case is that she is no way involved in the case. And purely on suspicious grounds, police has arrested him, my lord. And no case set out against the accused person. Therefore, she may be discharged from the my lord, the proceedings. Now, the learned trial judge, my lord, after hearing the parties, rejected that, my lord, application filed by the petitioner, accused, my lord, which I have annexed. At annexure, my lord, your lordship will find 16.
Who are you in the entire fiasco?
My lord, as per
There
the
were two
FIR,
persons, Kasim and Karthik.
yes.
Where do you come in?
Lord,
Huh?
your, if
40.
you- if your lordship pleases
You
to
don't
see
have a
the
page?
FIR, my lord.
Hmm.
FIR will disclose everything.
Are we on criminal revision 222?
My
We
lord.
don't have a page 40. Ours end in page 30.
That dated 18/6/22. That is or annexure H.
We are on different.
Indrajit Bora.
We are on
It's
Krishna Sinha.
Krishna Sinha.
Ah.
Well, the FIR says that these two accused persons, my lord, the FIR named accused persons uttered my name.
Hmm.
That, my lord, I have handed over some, my lord, substances
Hmm.
to them for trafficking it
Hmm.
and to carry it and to, my lord, give it to, my lord, destination at Guwahati, from Silchar to Guwahati. Now, my lord, police on information, I was also, my lord, traveling in a night bus.
Hmm.
From the night bus, my lord, I have been detained. Page 22, your lordship will find, my lord.
Hmm.
This is the FIR.
Yes, what is wrong in this? What is wrong in the framing of the charge?
My lord, I have stated in my ground, my lord.
So it is so much better to hear it from you instead of us reading from para to para. If you would say it, we would be happier
My lord.
that this is the ground.
But LCR was called for. I
We
think-
have it. But that will not reflect the working of the brain of the. We'll have to hear it from you. You have to tell us
My lord.
that this is the wrong.
Your lordship, kindly see, my lord. The paragraph, page 18, my lord.
Hmm.
My lord, paragraph number 11.
Hmm. Page 18, paragraph 11. Yes. Hmm. Judge or consider sifting with the evidence for
Kindly see, my lord, page 12, page 17, paragraph 12.
page.
Page 17, paragraph 12.
Ah.
May I read, my lord?
Hmm.
The Honorable Guwahati High Court in Nandan Das versus State of Assam 2021 2 GLT 741 observed.
We have read it.
My lord. Then Tufan Singh, my lord.
Hmm.
Sajjan Kumar, my lord, also says,
Yes.
where, my lord, if there is no prima facie case, my lord,
Two persons are
Now-
arrested with contraband. They say you are traveling in that particular bus on that particular seat number. You are picked up from that bus and that seat number. That is the charge against. That is the allegation against you.
they say, my lord, I gave them the contraband,
And they identify the bus number and the seat number where you are traveling.
my lord.
On that ground, you are arrested from the bus,
Correct.
forwarded together with them.
Correct.
Investigation is done.
Not with them, my lord. They were somewhere else.
Forwarding report accused person reveals all the three accused persons were forwarded together at
Yes.
page 16.
My lord.
This was your application.
Yes,
This was your application.
My
Or
lord.
this is the order passed.
my lord.
So you have to tell us that when you are arrested on the indication of the persons who were carrying the NDPS from a bus which they have identified along with the seat number, contraband has been recovered from these two persons and now the court decides to allow you to defend your case by framing a charge that you were one of the people. You will have the opportunity of cross-examination. You will have the opportunity of defense. What is wrong in the framing of the charge, sir?
My lord, prima facie, my lord, your
Hmm.
lordship will say.
We have
will-
given you the prima facie part.
My lord, lordship kindly
You were arrested
only
on
only on the basis of the admission on the part of the accused person
because
that he
they had contraband and they knew your seat number and your bus number in which you are traveling.
correct.
You are not picked up along with them.
No.
They tell the police,
Yes.
so and so bus, seat number so and so, catch.
Yes.
Is it not? So there is a chain.
Gave us.
Ah, so that chain is now there. That connection is there.
Correct.
So you are being tried together. What is the harm?
21 does not attract in my case, my lord.
Is there a stay?
There
Not no
is-
stay.
There is no stay.
We'll have it some other day because we'll have to sign all those orders last day of the court. Now we
But-
tried to
but-
find
but-
out if we could decide this.
My lord, there is another application, my lord, IA
Hmm.
for grant of bail, my lord. She is 1.5 years, my lord, in jail. She is having 2 children, my lord, school-going children.
Ah,
Her husband is also unemployed, my lord. He was working in some private company, my lord. Now these 2 children, my lord,
when
Yeah.
were you arrested?
Lord, 9 on the day, my lord, the information FIR was lost, my lord. 9/5/2024.
What is the amount recovered?
That is, my lord, your lordship will find.
See, for bail, these have to come out quickly.
5 to 8 grams.
528 grams.
Yes, 528
Hmm?
grams.
Heroin. Commercial. 37 will come in,
30%
sir.
commercial, my lord. Yes, it's commercial.
One more month.
And my role, my lord, your lordship.
One
can-
more month on the 3rd of February. We'll consider either the entire revision or at least your interlocutory application. We tried to find out if we could allow the criminal petition. This petition, if we could allow it. We'll need some time to be convinced. We are being convinced otherwise. So we don't want to do it today. We'll keep it for the 3rd of February. Maybe you can have some more convincing grounds. The trial court records as called for has been received. List this matter again on the 3rd of February 2026, on which day an attempt, the criminal revision petition shall be considered in entirety. On which day it shall be it shall be heard on entirety. We'll have it on the 3rd of February.
Including the bail application, my lord. I'm obliged. my lord.
Admission টা আসলে বলে দিলে ওটা কি হয়েছে? হয়ে গেল। Item 20.
May I please, Lordship? Lordship, my senior is suffering from a toothache, so he couldn't able to appear today. So, a matter will fix another date.
The spelling for the missing tribe is MISING. Has been reflected as MISSING. If that whole tribe goes missing, madam, we have to lodge another FIR. Ms. Swensel, Audit Council, appearing for the petitioner, has prayed for listing of this case on 5th of February. On the 5th of February for hearing, full stop. Learned APP does not object to the same. You are appearing for, Miss So appears for?
I am appearing for B. Sharma, Special PP Wildlife, and I am Escolita.
Miss Escalita appears for the Learned Special Counsel. Wildlife. One step. List the matter on 5th, 5th of February for hearing. হৈ গ'ল? সেইটো লাষ্টত সেইটো এইটো চেম্বাৰ দিলো ইয়াত বহি ডিক্টেশ্যন এওঁলোকে বহি থাকিবলৈ আপোনালোক বহি থাকিব লাগিব নিজৰ কাম কৰক যাওঁ এইবিলাক উঠি থাকে কেলে এইবিলাক